Today, I think we'll get started here shortly. We have today, I think, a great topic that's very timely. We're going to be talking a little bit about these wage and hour laws, especially how they're going to be changing. Obviously, I won't be doing the talking. I don't know anything about it. So we have Tanick and David McKinney from Ogletree Deakins here today. They're going to be talking about this topic. And myself, Mike Traeger from Minnesota National Bank, and Jennifer Nelson, we just want to thank you all for coming. These lunch and learns, we're glad you're all able to attend. These lunch and learns really, I think, are a good way for small business owners to stay informed of topics, whether it's ones like this, where it's talking about how you need to compensate your employees for their time, or whether it's social media marketing or things like that we've done in the past. We thank you for attending, and we also want to tell you that there will be some other topics that we're going to have coming out throughout the rest of the year, and into early next year. So, please be watching for that. This is kind of the season where we've been doing these over the last few years. So we'll send out more information to you along with the chamber, and invite you to those down the road. So if you ever need to stop into the chamber, I'm sure Jennifer's willing to come and listen to you, and would like your input on any ideas that the chamber might be able to do. And the same thing with the bank. If there's any way we can help you out, whether it's an operating loan or getting a better checking account or doing remote deposit for your business, just let us know. So I'm going to turn it over to Andy now, and he'll talk about your topic today.
Okay. Thanks, Mike. Hello, everybody. Thanks for having us here today. We're happy to be here and going to have some fun. David has never had the pleasure of being in Sauk Center before, but some of you may know that I have a connection. If you know the Banal family, I'm married to one of them, Susan. So my mother-in-law lives a little ways away from here, and I have all sorts of other in-laws in the Sauk Center area, so I've been up here a lot. We're going to be talking about wage and hour law, obviously, including all the new laws that you've probably heard about. There's a printout of the PowerPoint at each setting, and there's some space in there to take notes if you want to. We would welcome questions at any time, so just feel free to raise your hand or shout out or whatever. And we, I don't know if any of you saw the debates last night, but we thought in the spirit of the debates, we would kind of try to, pick up from where they left off. So David's he's going to be Donald Trump. He's going to just interrupt me and insult me the whole time. And I'm going to just smile, but then I'm going to erase all your emails before you leave. Why are wage and hour laws a hot topic? I mean, a lot of people are here today, so obviously it is. And you guys asked us to come up here and talk about it. It's an area that's really growing legally in terms of the types of claims that employees or former employees bring against their employer, the types of cases that we defend. I should have mentioned we work at a firm that just represents businesses in HR issues, so we defend these types of claims. We advise employers on how to have good policies and good procedures so they don't get them in the first place. So why is it such a hot topic? Well, in the current administrations, both at the federal and state level, whether you agree or don't with President Obama or Mark Dayton on most things, they are very committed to more on the employee side and less so much on the employer side, let's put it that way. So they have really kind of, some would say declared war on businesses in some of these areas. The Department of Labor, which is a federal agency we'll be talking about, has stated that they believe that 70% of all employers in the country are violating these wage and hour laws in some way or another. The State Department of Labor and Industry, which is the state version, I don't have any quotes like that from them, but they are in some ways even more aggressive than the federal agency. The number of lawsuits that have been filed about wage and hour issues has doubled in the last 10 years. It's actually gone up by 7 times in the last 25 years. A lot of these cases are class actions, and there have been 4 times more wage and hour class actions now than there were about 20 years ago. And there's more wage and hour claims, lawsuits, than there are discrimination and harassment claims at this point. The Department of Labor, that federal agency I mentioned, has hired 350 full-time investigators since 2010 just to focus on wage and hour investigations. So that's one of the reasons is the agencies are really focused on them. The other thing is that the lawyers who represent employees are focused on them. You know, if you have a choice as a plaintiff's lawyer of representing someone who claims that her boss touched her inappropriately, or a class of 10,000 Walmart employees who claim they weren't paid for their breaks, you can imagine which of those cases is going to put more money in your pocket. So they're much bigger money types of cases. They're easier to prove because in a discrimination case, you have to show they fired me because of my age or my race or whatever. You have to show intent by the employer. In an overtime case, you don't. Even if the employer didn't mean to not pay you overtime, doesn't matter. You can still sue them and win. So they're easier cases for the employees, and they're bigger money cases. The lawyers like them, the agencies like them, and you're stuck with the results of that. So that's why it's a kind of a big topic these days. So where do these laws come from that we're going to be talking about? There's basically three sources. We have, under the federal law, we have the Fair Labor Standards Act, FLSA. So this is the federal law that talks about overtime, minimum wage, child labor, all that sort of thing. Since it's a federal law, it applies to the whole country. There are some employers it doesn't apply to specifically, and we'll talk about that in a minute. But that's kind of the main source of most of these laws. Then the state, each state also has its own separate state laws. Minnesota, that has its own version of the Fair Labor Standards Act, which is we refer to as the MFSLA, or the Minnesota Fair Labor Standards Act. And Minnesota also has another set of laws in the statutes that deals with more kind of day-to-day issues like paychecks and travel time, whatever, just how people can get paid, how you have to pay someone on their last day. You have to pay them within 24 hours or just to the next payday, whatever. So that's the third source, another source of state law.
And so under the federal, is this too loud? Okay. Under the federal Labor Standards Act, FLSA, and the Minnesota FLSA, we'll be talking about what coverage looks like under these statutes, and in particular what the minimum wage requirements are. There's some that that went into effect August 1st of this year. We'll talk about overtime pay provisions. We'll talk about your requirements as an employer in terms of record keeping and what you need to keep, how you should keep the records. And we'll talk about regulations as it relates to child labor. Folks who are working on, kids who are working on farms or bringing them along in the office, doing a little bit of work here and there. And we'll also talk about how under the FLSA, or Minnesota Fair Labor Standards Act, laws about employers providing employees time for meals and breaks. And that's specific to Minnesota and not necessarily related to wage and hour, but is something that as an employer you want to be thinking about as you manage your workforce in terms of hours worked and scheduling and everything like that. And while the laws are somewhat different, generally employers should refer to the law that provides employees with the greatest amount of benefits, right? So we'll sort of point out the differences between what federal law requires and what Minnesota state law requires. And when you see that if there's differences between the two, employers should, generally speaking, go with the one that provides the most benefits to employers. That's how the law is typically going to look at the issue.
Okay, so the first thing Now, before you even have to worry about what these laws say is, do they even cover your business? Because some of them may not. You may be familiar with the Family Medical Leave Act, which is outside the scope of what we're talking about today, but it's an example of a law that doesn't apply to some businesses because you have to have 50 or more employees. So first question, do these wage and hour laws apply to me? So the federal law applies to most employers. It's got two requirements. You have to be involved in interstate commerce. So what does that mean? At this point, it kind of means everybody for all practical purposes. If your business buys anything from outside of Minnesota, or if you sell anything outside of Minnesota, you are in the quote stream of interstate commerce, as the law puts it. So this is kind of it's one of their requirements, but it's somewhat irrelevant these days. When these laws were first passed in the 1930s, there were a lot more businesses that were purely local. We didn't have the internet, we didn't have all the shipping and all that, so that's somewhat irrelevant. There could be, a very small business that only does business locally that this would apply to, but it would be rare. More importantly, maybe there's also a requirement for not the size of the business in terms of the number of employees, but the size of the business in terms of revenues. You have to have gross annual sales of at least $500,000 a year to come under the federal Fair Labor Standards Act. So that part of it does get some small businesses off the hook in terms of the federal law. There are some types of businesses, as you can see there, that are covered even if they are under $500,000. Hospitals, residential care, schools, and public agencies. So that's the federal law. Now, you may think, we're under $500,000, so none of this applies to me, so I'm going to just eat my pizza and go home. But not so fast, because the state law doesn't have any such requirement. State law applies to anybody in an employee-employer relationship, and you wouldn't be here today if you weren't in an employee-employee relationship, I'm pretty sure. So if you have any employees at all, you're covered by the state law. There are a lot of types of businesses, though, that are specifically outside of these laws. So the laws will say, here's who's covered, and then they'll say, but here's a list of specific industries that aren't covered. So, for example, under the federal law, amusement parks, recreational facilities, camp and educational conference centers, fishing, agriculture, maybe an important one, smaller newspapers, switchboard operators, babysitters, border patrol agents, they're specifically outside the federal law. The state law has exemptions too. Most importantly, for your purposes, perhaps the agriculture is not exempt under state law. So if you're a dairy farmer, for example, you aren't covered by the federal wage and hour laws, but you are covered by the state wage and hour laws. So you might think, I don't have to pay overtime to the people that are working on my dairy farm because I'm not covered by that federal law. And someday the state law, the Department of Labor and Industry might come knocking at your door and say, guess what? You're not covered by the federal law, but you are covered by the state law. So that's an important distinction. The state law does have exceptions for some salaried agricultural workers. It's not as broad as the federal law exemption, though. It also, in the state law, accepts corn detasselers, seasonal day camps, circus fairs, employees, ski employees, ski resorts, carnival workers, elected officials, babysitters, taxi drivers, police, firefighters, miners who work part-time at municipal recreational programs, conservation officers, pilots, and clergy. So unless you are employing people in that group, you are more than likely covered by the state law, even if you're not covered by the federal law.
So in terms of what the law actually requires, remember we talked about the minimum wage requirement. And under federal law, as you probably know, the minimum wage requirement is $7.25 an hour. But under Minnesota state law, as of August 1st, the minimum wage requirement is $9.50 per hour for large employers, and that's going to be employers who have annual gross revenue, volume of sales made or business done of $500,000 or more, and $7.75, so still 50 cents more than the federal minimum wage for small employers. And that's basically going to be everyone else. I mean, any business with less than $500,000 in annual sales revenue. And then there's some other categories that apply, but still at $7.75 an hour for employees who work who are under the age of 18. We'll talk about child labor laws in a moment. And for employees who are under 20 years of age, you can pay them the same rate for their training time within the first 90 days of their employment. The wage requirements apply to both full-time and part-time employees, so there's no real distinguishing a wage minimum for part-time and full-time employees. Doesn't matter if they're hourly or salaried, if they earn commission, or even if they're doing piece rate type work. The employer has a responsibility to, regardless of how much an employer would pay for piece work, that at the end of every hour, or that at the when you're doing the payroll, that they're meeting that minimum threshold. These apply to all hours worked, so there's no, again, the minimum applies if there's training time that people are going to. You can't pay them. Some employers may pay a different rate, and that's fine as long as the minimum is at $7.75 an hour, or $9.50 if you're a large employer. For certain break times, typically, generally speaking, any break times that are under the 20-minute mark should be paid time, and we'll talk about breaks later on in the presentation. And really any other times when, as an employer, requiring an employee to be available and otherwise work. I should mention one other thing here is that in Minneapolis, and I think in St. Paul as well, some of the unions and other employee groups have started to push for increasing this in the state of Minnesota, or at least in Minneapolis and St. Paul, to $15 an hour. Throughout the country, you've probably seen and heard cities and municipalities that have gone to $12 an hour. I think New York actually went to 15. So I think over the next couple of years, it's probably likely that at least in the cities, you'll see this hike up, and who knows if it'll go throughout the state or not. But these are the numbers for now, and as employers, make sure that you're complying with it and paying the employees this minimum threshold rate.
Just let's go back once we did the tips. Do tips count toward the minimum wage? The answer to that question is different between federal law and state law. Under federal law, tips do count as long as the person's getting $2.13 an hour straight pay, and you have to give a written notice to the employees that you're going to count their tips. But the state law says no. So in state law, you still got to pay the $7.75 or $9.50 an hour, even if people make more than that with tips. So that's minimum wage. So what about overtime? Kind of talk about some of the basics here. So federal law, the one that we're all pretty familiar with, if someone works more than 40 hours in a work week, which means a consecutive 7-day period, you've set, our work week goes from Sunday till Saturday or Monday through Sunday. You can't conveniently change it every week, but it would be a 7-day period. After 40 hours, the person has to get 1.5 times pay. A distinction under state law that many of you may not be familiar with is that in state law, the overtime requirement doesn't kick in until somebody works 48 hours a week. So why is that important or not important? It's not that important because, like I talked about before, you're probably covered by the federal law anyway, but it is important because if you don't meet that $500,000 threshold, you're not covered by the federal law. Or if you're in agriculture, there's the exemption under federal law that I mentioned before, but not under state law. So if you are a dairy farmer and the state Department of Labor and Industry does come knocking at your door saying you should have been paying overtime, they're going to say you should have been paying overtime after 48 hours. They're not going to be saying it after 40. So you get a little bit of a break under the state law. So that's the basics. There are some types of businesses that are not generally exempt from these wage and hour laws, but are specifically exempt just from the overtime regulations. That would include Department of Transportation employees, dairy buyers, radio and TV employees in smaller markets, vehicle sales, car dealerships, the sales, the parts people, delivery employees, waterway employees, taxi drivers, firefighters, police, movie theaters for some reason, timber, woods employers, national parks and forests. Those are all federal exemptions just for overtime. So we talked about minimum wage and we talked about overtime. What about the third area, major area that's covered by this federal law is child labor. All the basics are on the PowerPoint that you have in front of you, so I won't just read through them here to save a little time, but as you can see, the requirements for child labor varies based on how old the child is. So there's more flexibility if they're 16 or 17, less if they're 14 or 15 in terms of what hours they can work, number of hours they can work, and under 14, very limited in terms of what they can do. The one, things that you would think of, babysitters can be under 14, child actors, otherwise there wouldn't be any child actors. Newspaper delivery, those types of things are okay for under 14, but it's pretty limited. So if you have anybody under 18, you should make sure that you're not breaking the Fair Labor Standards Act by having them work more hours than they should, or coming in before they should, or staying after they're allowed to stay. There are separate rules for agriculture employees in terms of child labor. So as you can see, during school hours, so whatever that is, 7 to 3 or whatever, or if they're working with hazardous machinery, they have to be at least 16. If it's outside school hours, so nighttime hours, weekends, it can be at least 14, so they can be 14 or 15. If they're between 12 and 14, so 12 or 13, they can only work in agriculture if one of the parents works at the same place and has consented to it. And under 12, they can work only in a family farm, actually owned by one of the parents.
So in terms of record keeping, and particularly notice requirements, under both state and federal law, employers are required to post notice of an employee's rights in a conspicuous place at the employee's work site. And I'm sure you all have these posters already posted and have seen them. They typically are in break rooms or hallways that lead to break rooms. That's where they almost always are. And employers have also started to post them on their intranet sites, if you have an intranet site that you use for employees, so that they're also made aware and provided notice on those sites. Employers are also required to maintain records of each employee's pay and hours for at least 3 years. So I know the file cabinets can get thick. You can also keep them electronically, but it's important to maintain them for that three-year period. Some employers are doing a little longer than that. For timekeeping records, it's important to make sure, obviously, that they're complete and accurate. That's under the statute. In terms of posters and notices, if you if you're an employer who haven't seen a notice or don't have a poster, you can go online, you can go to either the Federal Department of Labor website or Minnesota's counterpart, and you'll be able to get the language that's required for the notice requirements. This is also important in terms of the, I don't know if you, again, the cities have, both St. Paul and Minneapolis this year adopted paid leave regulations that apply to workers who work in Minneapolis and St. Paul, even if the employers are located other places. And there's some requirements around being accurate to know how much an employee works for them to qualify for some of this paid leave. So that's another reason why it's important to keep the records accurate.
David mentioned the websites. The federal one is really easy to remember. It's just dol.gov, Department of Labor. The state, I don't know offhand, but if you just Google Minnesota Department of Labor and Industry, you'll come up with that. And that, like he said, they not only have a list of what you have to have posted, but I think there's links where you can have them send you the posters for free. Jennifer just told me that probably the most important thing you'll hear us say all day is that you can go back for seconds if you're still hungry. So help yourselves. Thank you, Jennifer. So one other thing that is covered by these Labor Standards Act, by the federal one anyway, there's a provision in there that says that you can't retaliate against an employee who makes a complaint, raises an issue under this law. So if somebody calls the Department of Labor and says, hey, my employer's not paying me overtime, you can't fire them for that. Retaliation is illegal. They can either, if they are retaliated against, they can either file a complaint with the Wage and Hour Division of the Department of Labor, or they can just file a suit. And this applies even if the employee is not actually covered by this Fair Labor Standards Act. So if you are under $500,000, so you don't have to pay someone overtime, let's say, under federal law, but they think that you do, and they make a complaint, even if they're wrong, you can't retaliate against them. And state law doesn't have a specific provision like that, but it does have a much broader whistleblower statute that says you can't retaliate against an employee for making a report of anything illegal. So whether it's about overtime or that you're dumping toxic chemicals in the river or whatever, you can't retaliate against employees who make good faith reports either to a government agency or to you as the employer, or you're violating the Minnesota whistleblower statute. And these can be expensive cases. Whistleblower claims are pretty common under state law anyway, and if somebody sues you for that and wins, they can get back pay if you fired them. They can get reinstated if you fired them, and you can have to end up not only paying your own lawyer, but also paying their lawyer if they win.
Now, in terms of breaks and what an employer is required to give to an employee during the workday, the federal statute doesn't speak to it, but Minnesota's state law does. And there's no specific amount of time that's set forth in the law for how much time you're required to give. But in terms of bathroom breaks, every 4 hours, an employer is required to give enough time for an employee to use the bathroom. And for meal breaks, it's every 8 hours, and the suggested time frame is about 30 minutes for lunch. I mean, the general practice is that an employee who's working about an 8-hour shift typically gets about 2 15-minute breaks that are paid, and then a 30-minute unpaid lunch break. There's also a Minnesota law that specifically relates to mothers who need to express milk, and the law requires that employers provide a private area that's not a bathroom, so a separate private area with an outlet where the mother can go to express milk. The employer is required to provide reasonable time for a mother to do so throughout the workday. It doesn't have to be paid. but it does have to be reasonable time, and those breaks are covered by the law. Any questions about that? Or any questions about anything we've gone over so far? Good. Oh, yes. Great.
Question from the very beginning when you were talking about the difference between the Federal Labor Standards Act in Minnesota, and you talked about interstate commerce, and you said if someone buys or sells across state lines, they're covered by the federal law. So if they have less than $500,000 in sales and they buy products from another state, they're covered by the federal law?
No, the question was if you, and this, I'm glad you asked because I wasn't clear, obviously. The interstate commerce and the $500,000, you have to meet both of those to come within the federal law. So if you're under 500,000 and you're in interstate commerce, you're still not covered, right?
Yeah.
Okay. Just need a reality check sometimes.
Yeah.
Yep.
On the brakes issue, what if you have employees that do not want to take their break, they just want to work through, either for the break or for a meal?
Yeah, the question, I'm just repeating them for the cameras. If an employee doesn't want to take their break, and we get that question a lot, you know, this employee wants to work through their lunch break so they can leave a half hour earlier, right, or come in a half hour later. It's a violation. I mean, technically it's a violation. What I would be worried about is that at some point they're not happy about something, or maybe they've been let go and now they're going to say, oh, I never said I wanted to do that. You know, you told me I couldn't take a lunch break. So, you know, it's technically a violation. You have to basically force them to take the break, and the danger is that while they may be all happy about it now, at some point they might not be, and the story might change. Employees tend to do that sometimes. You know, all the things that they were happy about when they worked for you, now that you fired them, all of a sudden they're not so happy about when they go talk to a lawyer.
I think that one other thing, because this does come up a lot, is that as an employer, remember going back to the record keeping piece, an employer needs to make sure that they're accurately recording the time, both, you know, that the employee is working and taking breaks. Because oftentimes you'll see an arrangement like this where then you've got an employee who shows up taking all these breaks, and then they come back and they say, well, I didn't take any of these breaks. And the employer, of course, has to say, you're right, we had this arrangement, but then you've got another issue with falsifying the records. So that needs to be accurately reflected, whatever the break is on the records as well.
And you can't get around it by saying, well, you were scheduled to work 8 to 4:30. Why don't you just take your meal break at 4 o'clock and go home a half hour early? That the Minnesota Department of Labor Industry will just see that they worked 8 to 4 and didn't get a break, and they will nail you for it.
Yeah.
So one other area that's covered by these state statutes is not covered by the Fair Labor Standards Act at either the federal or state level, but by those other separate statutes I mentioned before. It involves kind of the nuts and bolts of paychecks. So under these laws, you have to pay by a non-negotiable check or order. Well, we all do that, but you can't pay someone cash under the table. You have to pay employees every month at least. 15 days if they're like migrant workers. One issue, a question that we get a lot is about the final paycheck. The final paycheck has to be paid if the person was terminated involuntarily. You have to pay within 24 hours, so you should probably bring that final paycheck to the termination meeting with you, or if you're not terminating them in person, mail it to them right away. If it's voluntary, someone quits, then obviously that doesn't apply because you didn't know they were going to quit, most likely. So in that situation, you just have to pay them on their next regularly scheduled payday. And another issue that comes up a lot is an employee left and they owe the employer money. We had loaned them some money, or we advanced them some pay. Maybe they work at a restaurant and they broke a bunch of dishes, or something like that. Can you deduct that from their pay? The answer is generally no. You can do it only under certain circumstances. You can deduct it from their paycheck if they agree in writing after the debt is incurred. So you can't have someone, when they start working for you, to sign something saying, I authorize you to deduct, if I break anything, to deduct it from my paycheck. They have to sign it after they broke whatever it was. And the written document that states what that is has to say exactly how much you're going to take out of each paycheck. Another exception to this final pay deal is that if someone works with money, like they're your accountant, for example, you do have a 10-day grace period to like audit the books before you pay their final paycheck. So another issue, what exactly do I have to pay people for? Do I have to pay people for travel time, for training, volunteer, all these things that you can see on the PowerPoint here? So we kind of said here what the requirements are. So I won't go over each of them because you can read them for yourselves. But one thing, clocking in and clocking out, there are cases, believe it or not, where people have gone to court saying, well, I should get paid for the 3 minutes I had to stand in line waiting to punch in. And the courts have said, for the most part, no, that's not unpaid. But one thing I want to note is that if you do have like a time clock situation, you can't round the time to the nearest 15 minutes or whatever in a way that comes out always against the employee. So you can't always round the start time back and round the finish time up. You can do a rounding if you do it the same direction, if that makes sense. So as long as you always round forward or backward, that's fine, but you can't fix it so that they're always getting the worst end of that bargain. Travel time comes up sometimes. If somebody has to travel overnight, they only are entitled to be paid for that time they're traveling that will be normal during their normal working hours. So if they are normally a daytime employee and they travel somewhere overnight at night to work the next day, that actually does not have to be paid. Donning and doffing is kind of a legal term that is used in some industries where people have to put on like protective gear, or if they're working like in a meat packing facility, they have to put on their robes and things. There's a lot of cases on whether they have to be paid for that, and the law is not very clear, frankly. There's cases on it, but they're hard to understand. But they basically say that if the time is indispensable to the person's duties, then it has to be paid. So if you have a specific question about that, we can talk about it afterwards because it's kind of complicated, but that's the basics of it. The only other one I'll mention is some people have jobs where they may work at a residential facility or something where they're actually permitted to sleep at night on the job. So do they have to be paid for that? The answer is yes, unless they're working less than 24 hours, then they don't have to be. But you can exclude up to 8 hours of sleep if they have a place to sleep and if they get at least 5 hours of uninterrupted sleep. Just a general concept about this whole hours of pay thing. What if somebody works hours they weren't authorized to work? We didn't schedule them to work till 6 o'clock. They just chose to work till 6 o'clock. So I'm not going to pay them for it. Or I specifically told them, you have to go home at 4:30, but they stayed till 6 o'clock, so I'm not going to pay them for it. No, you can't do that. As long as you know or should have known that they were working, they have to be paid. Now, if they violate a directive that you gave them, like nobody can work unauthorized overtime, you can take disciplinary action against them because they violated what you told them to do, but you still have to pay them for those hours. Okay, we're going to talk a little bit more about overtime, which is such a big issue these days with the new regulations, which we are getting to here. So the overtime laws obviously apply to some employees and not other employees. We all know that. So what employees are not entitled to overtime pay? Well, there's 3 tests that have to be met before someone is exempt from overtime. So a lot of times clients will say, well, that person's salaried, so they don't get overtime. It's definitely not quite that simple. That's one of the 3 tests, but it's not the entire test. So first of all, they have to be paid a certain minimum amount. That's the thing that is changing with the new regulations that we'll talk about. So if you have someone that is salaried and is a manager but is only making, you know, $12,000 a year or something, they can't be exempt. They also have to be paid on a salary basis, and we'll talk about what that means. That does not only mean that they're paid per year, per month. It goes a little bit beyond that, but they can't be paid hourly. And they have to have certain duties. So if you have someone who is a clerical employee, a maintenance employee, even if you pay them on a salary basis and even if you pay them $60,000 a year, they can't be exempt from overtime because they wouldn't meet this duties requirement. And we're going to talk in more detail about these things.
All right, so talking about the first test of the salary level test, which is the question of, are they paid enough, right? So think about it in terms of 3 different buckets, and the first is, are they paid enough to qualify to be an exempt employee? Well, first of all, there's 3 categories of employees in which a threshold amount, they have to make a threshold amount: executive, administrative, or professional employee. And Andy will talk more about what each of those categories of employees, what that terminology means for these employees. But in terms of just the threshold, these employees need to make at least $455 per week, or $26,660 per year annually. And don't get too used to these numbers because there are new regulations. They're in your slide. We're going to talk about them later. And they go into effect December 1st. So for now, these are the numbers. A couple months from now, numbers will change. And as you can guess, they're gone up. But so that's the number for now. As a computer professional, there's a lot of different categories of individuals who would fall under the computer professional test. The number is still $455 per week, or works out to be about $27.63 per hour. And as you can guess, for computer professionals, you can just see anybody that has an information technology type duty would likely fall into that category. And then for outside salespeople, there's no salary requirement. And then there's a separate rule which applies to highly compensated employees, and we'll talk about what that number is and what details of that in terms of the new rule that's going to take effect in December. You have anything else on this one?
No.
Okay. So that's the first bucket. Second bucket is the question of, are they paid on a salary basis? And what does that mean, right? Employees must receive each pay period a predetermined amount constituting all or part of the employee's compensation. The predetermined amount cannot be reduced because of variations in quantity or quality of the work. And subject to a few permissible deductions, employees must be paid salary regardless of number of hours or days worked. Okay, and this is key, because if an employer improperly deducts from an employee's pay, then the exempt status may be lost. So an employee then would be classified as non-exempt and would be then subject to the overtime provisions. In terms of permissible deductions, there's a number of them. Some of them include if an employee is taking personal full-time days of absence, except for sickness or disability, and then if they take a full day absence and it's because of a sickness or disability, it has to be related to a legitimate paid leave program. Right? Full day, you can also deduct full day absences resulting from written disciplinary policies or safety rules, as long as they're explicit, written, they know about them. You can make deductions based upon that. And I think the general message is be cautious about deducting pay from salaried employees. But if you do deduct it and it's possibly impermissible, there is a safe harbor provision. So the law does provide employers with some leniency to say if it's an isolated incident, if it was inadvertent, if it was clearly communicated that the employer doesn't tolerate or permit improper deductions. If you obviously stop doing the deductions, maybe you go into inadvertent, and if you promptly reimburse the employee, so if you find the mistake out and you say, oops, sorry, I didn't mean to deduct this, because maybe you came to the seminar today and now you're going back and adjusting it, that's fine. I think you'll be covered there.
There's a couple others that you can deduct for infractions of a workplace safety rule, if you have a written policy on it, and workplace conduct rule, same thing. Or someone is on FMLA, you can deduct for partial day absences. And if someone, let's say they start working on Wednesday and your work week is Monday through Friday, the first week you don't have to pay them their full salary. So if they start on Wednesday, you'd pay them for 3/5 of that week. Same thing in the last week. If someone leaves on Monday, you just have to pay them for 1 day that week. So this is important because even if someone is salaried, again, if you dock their pay for something that's not permitted, the Department of Labor is going to say, well, you say they're exempt, but you're not treating them as exempt because you're docking their pay, which indicates they're really hourly. So this person is entitled to overtime. And if the department finds that it's a regular practice that you're violating this provision, they could say not only is Mary here entitled to overtime, but everybody else that also is in that same job is entitled to overtime. So you have lost the exemption by docking Mary's pay for 1 hour. You've lost it for all the people on that assembly line or whatever. Well, it wouldn't be an assembly line probably, but in that exempt group, you've lost the exemption for all of them.
So certain employees can be considered exempt, even if they don't fall within the two buckets we just talked about, two tests we just talked about. Those two tests just don't apply to them. We already talked about outside salespeople, but in addition to that, practicing physicians, practicing attorneys, teachers, and computer exempt employees paid at least that threshold per hour amount. Don't have to, those two tests we just talked about won't apply to them.
So we talked about how there's 3 requirements to be exempt. You have to make a certain minimum salary. You have to be paid on a salary basis without deductions except under limited circumstances. And the third is the job duties test. You remember I mentioned before that if someone is a clerical worker or a maintenance employee, they can't be exempt no matter how much you pay them or how you pay them. And that's where we get into this job duties test. And what that looks at is the, quote, primary duty that the person does. So the principal, major, most important thing they do. And they don't use a strict 50% type of test, but so let's say it's a restaurant manager, maybe 2/3 of the time he or she is waiting on tables or bussing tables to help out, but the other 1/3 they're doing more of a management function and supervising others. Even though that's less than 50%, the law would say, well, it's still their primary duty. They're just kind of doing the other stuff to help out, but the reason that they're there, their reason for existing at that restaurant is to be a manager. So that would be the primary duty, and they would pass the test. So when we talk about the primary duties, you may have heard people talk about the so-called white-collar exemptions. Those are kind of the main categories of types of employees who are exempt from overtime. There's all sorts of other little exemptions too, but the main groups are these white-collar exemptions. So you have executive, professional, and administrative employees. And I'm not going to go through to like read all this stuff, but you can see in the materials what are the requirements, what are the duties that you have to do to be considered an executive employee, first of all. This is basically the guy or the woman who owns the business or is at a very high level. That would be an executive employee. You can see the details of what the requirements are on the PowerPoint, but you kind of know it when you see it in terms of the executive. If they're running the business, then yes. The one that gets you in trouble as an employer much more often is the so-called administrative exemption. And that is not, you think of an administrative employee as maybe someone that runs the office or that sort of thing. That's not what this means. This is somebody who, as it says, their primary duty consists of performing office or non-manually work directly related to the management or general business of the employer or its customers. And it must include the exercise of discretion and independent judgment with respect to matters of significance. So we see a lot of cases involving like assistant managers. Well, that person is a manager, it says so right in their title. But they may not really be managing under the legal definition of what an administrative employee is if they're not. The work has to relate to the business itself, not just waiting on customers or whatever, but the actual operation of the business. And they must have the ability to exercise some discipline in management type decisions. The third one is professional employees. So this would be people with like normally an advanced degree, lawyers, doctors, architects, accountants, that sort of thing. They may not be running the business, but at that level of expertise and education, they are also exempt under the professional employee exemption. There's an exemption for certain types of computer employees also. It's not really considered one of these so-called white-collar exemptions because it was added after that part of the law. Clearly, I'm not going to read all this to you. You can read it for yourself. So there's, if you have computer programmer types of employees, look through this and see if they can be exempt. And there's the, what was it, $27.63 an hour, I think they have to make also, which is different from the other exemptions. And the last major category is outside salespeople. So this is not the person selling inside the store or by phone. This is someone who's actually out on the road making sales. They can qualify to be exempt under this outside sales exemption. As you can see, they must be customarily and regularly engaged in working outside of the premises. There is an exemption, limited exemption for inside types of salespeople. Those would be people that make more than half their compensation through commissions, and they work at a retail or service establishment. Their regular rate still must be at least 1.5 times the minimum wage, and they must actually work at the retail store. So they can't work down at headquarters or at the office. They have to actually be there on the floor. So that's the limited inside sales exemption. And David mentioned before that there's also, just in case that wasn't complicated enough, there's kind of a separate exemption for highly compensated employees, and they don't have to fit into the categories we talked about before, as long as they customarily and regularly perform at least one of the exempt duties that we've talked about. They don't have to meet the other requirements as long as they are paid at least $100,000 a year. And that's one of those numbers that you shouldn't get too attached to because it's going to be going away on December 1st. Speaking of which, David is going to now walk us through the new regulations.
Yeah, so forget everything we just said. No, I'm just kidding.
Except that you can get seconds, don't forget that.
Right. Don't forget that. And actually, the buckets and the tests that we talked about still apply. But as of December 1st, the U.S. Department of Labor has implemented a new rule that's going into effect that will apply to the FLSA, right? So it's federal law that it's applicable to. So if you're an employer in which the FLSA applies to you, this is something to pay attention to. And if you're here, you should pay attention anyway. It applies to a minimal threshold being raised for salaries. So we'll talk about what that number is. The Department of Labor now has a rule, as part of the rule, has added an automatic adjustment provision so that it will be fixed to inflation. So it'll automatically go up this minimum. That part of the law is currently being challenged in court, but for now, as of December, it will take effect in law. It will make some changes to the highly compensated employee compensation, be some increases in that we'll talk about, and then there's a provision that allows for non-discretionary payments to be made to meet the salary threshold, so that as long as basically bonuses can be made to meet the threshold amount. So you don't have to pay a highly compensated employee all of it in terms of a salaried amount. You can reserve some of that for a bonus. So applicability, we know the date now. We already know that what the FLSA applies to entities of 500,000 annual gross sales, as well as certain public welfare entities like hospitals and schools, and relates to employees engaged in interstate commerce.
Just to note that, because I know Jennifer mentioned that there may be some confusion. Well, we only have 5 employees or 8 employees, so we don't come under these new regulations. Again, that has nothing to do with it. All that matters is that you're covered by the Fair Labor Standards Act, which is the thing we talked about before, where you have to be both in interstate commerce and also have revenues of over $500,000. So if you meet those requirements, even if you have 2 employees, you'd come under these new regulations.
Okay. So the new minimum threshold salary threshold is $913 per week, or bi-weekly, we did the math for you to make it easy, and it's in the slide there. And again, this applies to executive, administrative, professional, and computer tech employees for exemptions.
So it applies to all the ones we talked about except for the outside and inside salespeople.
This is the automatic adjustment provision that I just mentioned. The minimum threshold will automatically be adjusted every 3 years using a 40 percentile of weekly earnings of full-time, non-hourly employees in the lowest wage census region, which this year happened to be in the southern region of the United States. And based upon that, you'll see that in 2020, the projection for the minimum wage increase, or minimum wage threshold, is scheduled to go up to $51,168 annually.
He means minimum wage in terms of being exempt, not the actual minimum wage. So
Right, yes.
don't panic.
Right. The minimum salary threshold for exemptions, that's right. Great clarification.
That would be important.
Right. And then the notice of actual updated salaries will occur with the Department of Labor will issue a notice of about 150 days before it's scheduled to take effect. In terms of highly compensated employees, The total annual compensation level is set at 90th percentile of earnings of full-time non-hourly employees nationally, so not based on per region. And so it was $134,004 annually based on the fourth quarter of 2015. The final regulations did not change annual catch-up payments at the end of the year or within 1 month after the end of the year. You want to talk about that?
Yeah, so that you can hit that 134 by giving them a pretty huge bonus at the end of the year if they're only making the minimum of $913 a week. That's the new minimum to be exempt. That's what that means. So while you can pay them less than that on a weekly basis, if you want to come under this highly compensated employee exception, you'd have to make up at the end of the year with a very large bonus.
And then, like the threshold we talked about before, this is annually adjusted, and so in 2020 it's projected to be $147,524 as the minimum wage. No, the minimum wage for exempt employees. So
we have, our firm has lobbyists in DC that are, give us updates on all this stuff, and there have been lawsuits filed, a couple I know of, to stop these from going into effect December 1st. And our sources tell us that they expect that that's still going to happen on December 1st, that those lawsuits probably won't be successful, but they may be successful in at least stopping the automatic increases every 3 years. So stay tuned on that, but you should probably assume that the December 1st date is good to go.
This is the other piece I was talking about with bonuses, which is that under the regulations or new rule, an employer is permitted to provide 10% of minimum salary may be non-discretionary bonus, incentive, and or compensation payments. So if an employer wants to adjust that minimum threshold amount down by 10% and reserve that into some type of non-discretionary bonus that's paid out, and this might be helpful in terms of maybe cash flow or other projections, an employer can do that. The non-discretionary payments must be paid quarterly or more frequently. Again, Andy talked about the catch-up provision.
And just, if you're doing the math in your heads, you're thinking, well, if I paid the person $913 a week, I'd have to pay them a lot more than the 10% bonus to get up to that 134. So just to clarify that the 134 is the highly compensated employee part of the law. Under that part, you can pay a bonus of more than 10%, but everybody's making less than that. The bonus at year end to get them above this new threshold is limited to 10%.
Okay. And we included in here some suggestions about what you can do in terms of preparing for the December 1st deadline. Obviously auditing, looking through your employee roster and the compensation that they're receiving, doing an audit to find out if there are any employees that may qualify for changing categories because of the new limits. And if so, if they may you may have them classified as an exempt employee now with the threshold. You're not paying them what the new threshold will be. Employers need to make a decision as to whether they're going to increase that threshold, increase the employee's salary, or whether you're going to just let them be non-exempt employees. And if so, if you want to have them actually move up to that wage, you'll need to get into place ways in which you can do that. Are you going to do it now? Are you going to do sort of a step-up type increase, getting you to December 1st? Those are certain ways to do that, and obviously the communication plan for employees on how this is going to affect them is important. And then consider, the implications that it has to your payroll systems, particularly if you're using an outside vendor, as well as your internal human resources systems and policies.
And just a couple of things here. One issue that my clients are having is, well, if we bump that person who's kind of at the low end of the totem pole up to this $9.13 a week, you know, that's all well and good, we can survive that, but that means the people that were, you know, 1 or 2 steps ahead of them on the totem pole, they were only making $9.15 a week or whatever. So now we call it compression, wage compression. So that's another kind of, you know, unintended consequence of this. It may require you, not legally, but just as a matter of keeping the masses happy and, you know, stopping a revolt from happening in your workplace, you may have to raise other people's pay also so that they're still, you know, making more than the people that have gotten bumped up to this minimum. Again, you don't have to do it legally. I'm just talking about more of a HR issue that you may end up facing. One other thing, if you choose to say, well, rather than bumping that person's salary to the new threshold, I'm just going to start paying them overtime. You can do that. That's, you know, the other way to deal with these regulations. One danger with that is that a smart employee might say, well, wait a second, well, if I'm entitled to overtime now, why wasn't I entitled to overtime before? I think you should have been paying me overtime all along, because, you know, you're saying my job is non-exempt. Well, that hasn't changed. I'm still doing the same job. Just because the minimum salary went up didn't change my job. So, and we face this same issue, like if a company does an audit of all their employees to see if they're properly classifying people as exempt or non-exempt. Sometimes we'll end up telling them, well, you know, these 5 people that you haven't been paying overtime for because you think they're exempt, they're really not, so you should start paying them overtime. And again, you do that and they say, well, wait a second, why now? You should be paying me for all those years I wasn't getting overtime. So one thing that you can do is, you know, if you can legitimately change the job somehow in maybe some minor way to say, well, that's because you were doing that before and now you're doing this, and it's different in some way, then you can get away with it. If you roll it out with kind of some overall, you know, we've got new job descriptions for everybody, not just for you, and in coming up with these, we've decided to reclassify you. So there are ways that you can try to ease this transition to reduce the risk that a clever employee is going to come after you for all the overtime that they haven't been getting paid in the past.
Any questions? We're going to transition to sort of another subtopic that's related to wage and hour, but, you know, this is a lot to digest. So just any questions relative to these new regulations? Okay.
Okay, well, we just have a couple other things. Somewhat, you know, related topic. I don't know if any of you have independent contractors at your workplace. One of the other areas in which these government agencies are really coming after employers is saying, yeah, we're not buying it. That person's not really an independent contractor. I don't care if they have an agreement that says they are. They're not as a matter of law. So you should have been paying them overtime, or you should have been paying them minimum wage. You should have been giving them benefits. These are some of the reasons why you might have someone classified as an independent contractor, so you don't have to do those things. It can also be an issue with discrimination laws. They don't apply generally to contractors, but they do apply to employees. I've had it come up several times already with unemployment situations where somebody was an independent contractor and they're let go and they file for unemployment. And my client's like, well, how can they get unemployment? They were not an employee, they were an independent contractor. And the state unemployment office seems to be on kind of a vendetta on this issue and is not buying that either. They're often saying, no, that person was an employee. And that not only means, you know, overtime, but it could throw, you know, all the people in that group of employees into question in terms of whether you should have been treating them all as employees. So what is the legal test? Like I said before, it's not enough just to have them sign something saying, yeah, I'm an independent contractor. The law uses what's called an economic realities test, which consists of 6 factors that a court or the Department of Labor we'll look at to see if someone is really truly an independent contractor, and we have them listed here in the materials. If they are integral, working in an integral part of the business, more likely they're an employee. If their managerial skills affect profits and loss, kind of goes without saying, they're probably not an independent contractor. You would not normally entrust a contractor with that type of authority. If they are investing more in the facilities, the equipment, that sort of thing, that's again more likely an employee. If they exercise independent business judgment, that means they're probably a contractor because they're doing this on their own and not just following the directions that you're giving them. That's where the independent part of independent contractor comes in. Permanency and duration. If someone has been working with you for 20 years, it's going to be hard to convince anybody that they're an independent contractor. That's more likely to be an employee based on the length of time they've worked there. And I kind of mentioned a little bit before, the amount of control you have over the person, that's probably the most important factor. So the Department of Labor's or unemployment, whoever, they're going to look at how closely did you supervise the person? Did you tell them, you know, here, just paint the house, use your own supplies. We don't care if you paint it from left to right or right to left. You know, you're on your own, just make sure it gets done. That sounds more like an independent contractor. If you're telling them everything, every little minutia, what time to be there, you know, what equipment to use, then they're more likely an employee. So some tips if you're using independent contractors to protect that relationship. I mentioned a couple times about having an agreement, and I kind of said it doesn't matter. Well, it does matter. It helps to have an agreement. It's not going to end the question. You know, you could still lose, but it helps to have them sign something that says they're a contractor. Don't control the work, control the results. You know, I want that room painted in this way, but as to how to get there, that's up to you. Don't cover their expenses. An independent contractor should cover his or her own expenses. Don't try to have them sign a non-compete agreement. That would be a very bad idea because you can't control a contractor in that way. Let them hire assistants even. Don't include them when you have employee meetings, parties, the holiday parties, the softball game, whatever. You might feel bad because you want to include them, but don't, because that's going to make them look more like an employee. Similarly, they should not go through any kind of training or orientation. They should have that know-how before they come to work for you. Don't give them an employee handbook. They're not bound by that because they're not your employee. And if someone has been working with you for a long time and they're going to retire, don't bring them back as a quote consultant and say that they're an independent contractor doing exactly the same thing they were doing before. If they were an employee before, the Department of Labor is going to say, well, nothing has changed other than you're calling them something different, and that doesn't cut it. Finally, if you have an independent contractor who's doing the same exact job that an employee is doing, that is a problem because any of these agencies or a court's going to say, well, that doesn't make sense. If an employee is doing the same thing, we think this person's an employee. Just real quick, this is maybe something that doesn't apply to a whole lot of you, but there's an increasing issue out there about joint employment also. You're seeing it a lot with like franchises. Someone that works at the American across the street, they work for some local franchisee. They don't work for some big mother corporation in New York called American Incorporated. But courts have increasingly been tying both the franchisor and the franchisee together and saying if somebody discriminated against them or didn't pay them minimum wage or overtime, we're going to get both of you, both the franchisor and the franchisee. It can also happen if you have two related companies. Maybe you own two small businesses that are in some ways related. You may think that if somebody makes a claim for overtime or something, they're only going to make it against the one company. If your two companies are too closely interrelated, they could drag the other one in too and say that they're joint employers. So just real quick, the key here is to keep things separate. Separate books, separate employees, separate policies, separate supplies, all that, whether you're in a vertical relationship with a franchisor above you or a horizontal relationship where you own several businesses, to avoid this joint employment situation. Just make sure to keep everything separate between the two companies.
So I know everyone needs to get back to work and get on with your day. If you have any questions and you want to share them now, we're happy to answer them. We'll also stick around here for a while afterwards, and you can come up and ask at that point. Any questions? Yes, sir.
At any time, is working hours allowed?
You mean like comp? Yeah, okay.
Comp time?
Right, the question is about comp time. So clients will call me and say, well, this person worked, we accidentally let them work 45 hours this week, but they're going to take 5 of those hours as comp time next week, so we don't have to pay them overtime, right? No. There's no exception to these laws for comp time. If they work more than 40, you got to pay them overtime, even if they only work 20 the next week.
Great question. Anything else?
Yeah, I have a question. For the involuntary final paychecks, is it just money, or is it also supplies, equipment, and stuff that they would have access to that is working money to take inventory of before you get the final paycheck?
Okay, so like if you think the person might owe you some money back at their final paycheck, you say no?
Because you said if it's an involuntary, you have within 24 hours, you have
Right.
a paycheck. Unless there's a 10-day grace period, if you're dealing with money. Well, what if you have supplies and stuff that are worth money and you want to inventory that?
Okay. The question is about this 10-day grace period for final payment. Why I mentioned before that if the person is involved with accounting or something, you have 10 days to audit. And the question is, what about if it's not with money but other supplies that they may be responsible for? I don't think that 10-day rule applies then. Have you looked at that?
No, I
think
haven't.
it's only for people that are, literally involved in finances. But if there is a dispute about how much you owe them, the 24-hour rule is if there's a bona fide dispute about what's owed them, that's another exception to the 24 hours that you can say, well, we had a dispute, so I didn't pay them that amount they think they're owed. I paid them what I thought they were owed.
I think generally my own advice would be to just stick with the cash portion. So if it's accounting related to accounting for cash and books, that would apply. If it's supplies or other things, that would be a separate issue that you would need to, once you're accounted for it and if you found some deficiency, there would be other ways to try to recover it.
And we've just been talking about wage and hour laws. If you have questions about reasonable accommodations for disabled employees or for Muslim employees who want to have their prayer break, or what can I ask in an application, or sexual harassment or discrimination, feel free to come up afterwards and ask us, and maybe we'll come back and give you another hour on that whole separate topic at some point.
All right, so I think we're just about out of time, right? So thank you again for having us here and spending some time with us. If you have questions, feel free to come up afterwards. If you have questions after today, you've got our contact information. Give us a call, shoot us an email. Happy to answer it for you and talk through any issues that you might have. Thank you.